Hi friends, welcome to Litigation Landscapes. In this video series, we shall be discussing about strategies for successful litigation in GST. You must understand that in GST, if you get a show cause notice, 85% of the show cause notices ultimately gets converted to adjudication orders with the same demand. So when you get a show cause notice, you need to decide whether to accept and pay or dispute and litigate if it gets converted into an adjudication order. And if you decide to litigate, you need to build your foundation for the litigation at the show cause notice stage itself. Today we will talk about two constitutional provisions which can help you in GST litigation. These two provisions are Article 265 and Article 21 of the Constitution. What does Article 265 say? Article 265 says that no tax can be levied or collected except with the authority of law. So, this provision makes it possible for the governments to pass a taxation law and collect taxes from you and I. And we must also understand that the power to tax is not a default power as far as governments are concerned. They need to pass a proper taxation law and follow all the rules, regulations, procedures, etc., as laid down in this law. So it's not possible for the GST officer to walk into my office, look around and say, "Oh, Venu, you have a wonderful office here, and I'm sure you are very prosperous these days and you are doing very well. So why don't you pay 10% more taxes from the next month onwards?" Is it possible for the tax officer to do such a thing? It is not possible because Article 265 says that no tax can be levied or collected except with the authority of law. So when you get a show cause notice, the first thing you need to look is whether there is an authority of law. The section quoted is proper. The section enables the department to ask you to pay taxes, penalties, interests, etc. And if it is not properly as per the law, it is possible for you to challenge it on the basis of constitutional violation. Because without an enabling law, the government has no power to demand taxes from you and I. The next article is Article 21 of the Constitution. What does Article 21 of the Constitution say? Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. This article says that your life, personal liberties, etc., can be deprived if the state and instrumentalities of the state follow procedure established by law. So we need to understand what exactly is procedure established by law. And this constitutional provision is a seemingly harsh provision. And this was intentionally kept as a part of the Constitution by our founding fathers of the Constitution because they wanted the legislative to be supreme and they didn't want the judiciary to interfere in the laws made by the legislature. So, this is the reason they have put this article in the Constitution. They didn't want the judiciary to interfere in the lawmaking power of the parliament. And this article stood in that fashion, and the words procedure established by law was interpreted in the same fashion for a long time by courts. A case in point is A.K. Gopalan versus Government of India. In this case, A.K. Gopalan was taken into preventive custody and he moved the Supreme Court. So the Supreme Court interpreted procedure established by law by saying that the procedure which is prescribed within the law should be followed properly. The Supreme Court did not look at what can a law be, but it just said that procedure established by law should be meticulously followed. And in A.K. Gopalan's case, the Supreme Court found that procedure as laid down by the particular act was properly followed by the police officers, etc. So the Supreme Court said procedure established by law has been followed properly and it is not possible for us to interfere in this matter. And the jurisprudence stood in that fashion for a very long time. Later, in a very famous case called Cooper versus Union of India, which is normally known as bank nationalization case, an 11-member bench of the Supreme Court again interpreted procedure established by law. And this time the Supreme Court focused on the law. It said law means something which is within the competence of legislature and does not impair the guarantee of fundamental rights of constitution. So ultimately the Supreme Court said a law cannot be passed by parliament which can take away the fundamental rights as guaranteed by the constitution. So for the first time, procedure established by law has been interpreted on the side of the law. The word law has been interpreted by the court and it said a law cannot take away the fundamental rights guaranteed by the constitution. So this was a big deviation from A.K. Gopalan case, where in A.K. Gopalan case they were looking only at the procedure and whether the procedure was properly followed. Now in this case they looked at the law and said a law, even if passed by parliament, cannot take away someone's fundamental rights as guaranteed by the constitution. Further down the line, in another landmark judgment, a 7-member bench of the Supreme Court in Maneka Gandhi versus Union of India considered a complaint from Maneka Gandhi where her passport was impounded by the government of India without intimating her and she complained with the Supreme Court. Again, the Supreme Court interpreted procedure established by law, which is there in Article 21 of the Constitution. And this time the court looked at procedure as well as law. And the 7-member bench said procedure should invariably follow principles of natural justice. So if a procedure is laid down within a particular law, it cannot be in violation of principles of natural justice. So any procedure in any law which is not following principles of natural justice should necessarily fail. And the Supreme Court also looked at the law in the procedure established by law. And it said the law must be just, fair, and should not be arbitrary, fanciful, or oppressive. So this is the way Supreme Court interpreted procedure established by law. The procedure should invariably follow principles of natural justice and the law as described in Article 21 should be just, fair, and it should not be arbitrary, fanciful, or oppressive. And these two judgments were landmark judgments from the Supreme Court. And for the first time, India became a country with constitutional supremacy as against parliamentary supremacy. Till that time, we had a parliamentary supremacy because the jurisprudence was that if a law is passed by parliament and the procedure within that law is properly followed, one can take away the life and liberties of people. But afterwards, these two judgments together brought two things. One is procedure within the law should invariably follow principles of natural justice, and the law passed by parliament cannot take away the fundamental rights as guaranteed by the constitution, and that law passed by parliament must be just, fair, and should not be arbitrary, fanciful, or oppressive. So this is a landmark judgment, and this gives a lot of safeguards, rights, remedies, and safeguards for all the people whenever the parliament tries to infringe life and liberties of citizens. So now procedure established by law is subject to 1. Law cannot take away fundamental rights. 2. Law must be just, fair, not arbitrary, fanciful, or oppressive. And 3. Procedure must follow principles of natural justice. So, any violation in these three things will be helpful for us to directly approach the High Court with a writ petition. So, any violation of constitutional provisions can give us permission to approach the High Court with a writ jurisdiction. So, even in case of GST law, we don't have to go to the first appellate authority, then to the tribunal, and then to the High Court, and then to the Supreme Court. Instead, if there is any constitutional violations, it is possible for us to directly approach the High Court with a writ petition. So that is a big safeguard as far as our rights are concerned. And we must be very vigilant whether any of these things are happening. Any constitutional right is being violated, whether the law or the section passed is arbitrary, unjust, unfair, etc. And the most important thing is every procedure should invariably follow principles of natural justice. So you must understand that violation to allow you principles of natural justice basically is a violation of Article 21 of the Constitution. So you have every right to plead it. If you want, you can straight away go to the High Court. So these two provisions should be kept in mind. And whenever you get a show cause notice, we must meticulously verify whether any of these constitutional provisions have been violated by these provisions, etc. And if it is there, it is a big advantage for us in our litigation. Courts will definitely give us relief. Now we will discuss some other factors about litigation in GST in some other videos. Thank you for listening. Thank you.